Number 201, Hain versus Jamison. Counsel?
Good afternoon, Your Honors. My name is James O'Brien. I represent the appellants Jamison, and I would like to reserve 2 minutes for rebuttal.
You may, sir.
I'd like to start out by indicating that Drum's negligence in failing to adequately confine its calf due to disrepair of its fence, and then allowing that calf to meander onto an adjacent, dark, unlit, narrow country, 55-mile-an-hour road.
Counsel, do we know why the motorist stopped to help that calf? Or did she hit the calf, or what happened there?
The reasonable inference, Your Honor, is that the calf was in the road and that she stopped because she could not get past it. This is not Western Avenue here in Albany where you have 2 lanes on either side and you have bright lights. This is a very narrow, unlit, dark country road that has no fog lines, no center line. It's a very narrow. Someone coming around that corner, a jury could find is reasonably foreseeable that she had to stop because the calf was in her lane or in the road.
Does the record reflect what side of the road was it the farm was on, the north side or the south side?
Yes, it would be on the same side where the accident occurred, which I believe was the north side.
But does that explain her actually going into the middle of the road? You could stop and wait for the cow to move.
George, that's why I started with what the road looked like. Again, it's not Western Avenue. This is a very small road. If that calf is in the road, it's in the road. I mean, there's no way around it. If it's on the side of the road, it'd be very hard to go around it. If it's in the middle of the road, it's very hard to go around it. You just don't know. And historically, and the common law has indicated also, that cows have a tendency to wander. They don't just stop, they wander. So I think it's reasonable for a jury to infer that this calf was wandering around this little road, a narrow, unlit, dark, unlined road, and that she had to stop. She was forced.
Is there any way to determine, based on the nature of this accident, where on either of these lanes, or if across both lanes, or if it's on perpendicular or diagonally, is there going to be any evidence, or would there be any evidence that would help the trier of fact figure that out?
Yes, Judge, I think it's generally agreed, and the court found that it was agreed amongst the parties, that the calf was in the northbound lane, the one that Jamison was traveling at the time, at least the time it was hit. When the time that Ms. Hain and the calf was hit, it was in that lane, if you will.
The Fourth Department, they said it just furnished the occasion for what occurred, and it was not negligence in itself. How do you distinguish, or how do you answer that particular part of their decision? Because
it was foreseeable that someone coming upon the road would stop to move this calf. It's a foreseeability issue. Because you have a calf that's wandering in this road.
Well, let's assume for a minute that instead of a calf, the farmer had his tractor and a wagon, and a bale of hay fell off. And, you know, it's dark, it's everything that you described, and there's a bale of hay in the middle of the road.
That's a good distinction, because a bale of hay, like the ball in the Lee case, is an inanimate, non-movable hay. It's an object. It's in the road, it just stops. You can go around it. It's not going to move. It's not going to all of a sudden move when it hears a car. It's not meandering around the road. It is actually stopped in the road, and the negligence has concluded. Here, because this calf is wandering back and forth, presumably because that's what cows and calves do, it kept moving and caused
But if that's so, how is it foreseeable that someone would risk at night getting out if this calf is moving back and forth? You're going to be out in the middle of the road while there's an animal just going back and forth. That seems very high-risk behavior that one might not foresee.
Maybe not
as a response to having a calf in your lane, as you say.
Because how do you get past the calf? You have to go past it. Presumably, a jury could find that she was forced off the road and had to move the calf to get back on the road. Because
you're suggesting there's an element of perhaps comparative negligence.
Exactly.
Not
Exactly, because...
What if she had gotten the calf safely back to the farm, and then she was walking back to her car and got hit at that point? Would you still say that there was proximate cause in that situation?
Arguably not, because that's
What's
more
it-
of a Barnes case type thing, where at that point, the danger of the cow being in the road has concluded. The cow is now off the road, the danger has ended, the continuous nature of the drum's negligence in allowing the calf has concluded. So arguably, now she's walking back, and now she gets hit by a car. That would be more attuned to her own negligence and not seeing the car approaching her.
You know, one of the things with, I've always kind of struggled with the concept of furnishing the occasion in intellectually comparing it to substantial factor. I think sometimes it's hard to tell which is which. And the standard, do you say that the standard is that the intervening act, the moving the cow, must be both, it's when it's unforeseen and an extraordinary act? Is that what it has to be to meet the burden? Does it have to be an unforeseeable and an extraordinary act? Or is it a matter of context, whether or not you'd move the cow or not? You know, in other words, in a country lane, moving a cow off the road seems to be a normal act of neighborliness. It's kind of a normal act.
Correct.
And so, under that standard, this action would constitute a case of no good deed goes unpunished. But in another situation, driving around a bus was stopped to pick up a passenger, that seems to be a kind of thing you should expect on a city street, and that intervening act would not constitute a foreseeable act and it could be furnishing the occasion for an accident. So that distinction between substantial factor and what test to apply, I think, is what I struggle with. I'm asking you, I guess, how do you see it? How would you characterize it?
I think it's a foreseeability issue. Mm-hmm. Is it foreseeable that if someone was approaching a cow on a dark, unlit road, that they would stop? As opposed, you mentioned a bus. It's not foreseeable that someone would run into the back of a bus that's stopped in its proper location. So, and I think the when you're looking at superseding causes, mm-hmm. here the risk that was to be seen or foreseen or guarded against was exactly the cow getting in the road. Why is it a problem with the cow getting into the road? Because
so by my question, I'm assuming negligence on the drum farm, that the cow's wandering. Let's just assume for the purposes of the question it's negligent.
Yes.
Yeah.
Well, it seems it's foreseeable, again, getting back to my other question, that the car will stop. It's whether or not she's going to get out and get in the middle of the road at night.
Well,
She could just wait for a while. This seems to have moved very
Right.
quickly, right? So she comes upon the calf, gets out, and gets hit, as opposed to waiting and seeing, as you say, the cow is moving around.
cow's moving around, another car comes upon the scene, she gets rear-ended. As a descent found below, even if, no matter if she came around that curve and stopped her car, another car could come around, hit her, see the cow and then hit her, or hit her, then the cow, or
Do we
vice
know
versa.
how long she was there before the accident happened?
No, we do not know how.
Nothing in the record
no.
about that?
No, under the noseworthy rule, though, the plaintiff's burden would be lessened because she's deceased. She never, she died on impact.
Well, how much time elapsed between the time that the neighbor saw the cow and went to tell Mr. Drum,
Right.
and when he hears the accident? I thought he also heard the accident.
That was probably within about 5 or 10 minutes. That exact amount of time is not known, but what we do know is that the neighbor stopped, called another neighbor and said, "What should I do?" And he said, "Well, just go right to the Drum farm and tell them." So we can, I would assume, it's not in the record, but it was a matter of minutes, not a half hour. We know it was about another half hour to 45 minutes before the accident occurred.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. May it please the Court. My name is Ellen Sturm. I represent the estate of Holly Hain, the decedent in this matter. I request no time for rebuttal. I have a preliminary argument that I would like to make, that although plaintiff did not seek leave to appeal the Fourth Department's order, plaintiff certainly has been aggrieved by it, contrary to the Drum defendant's contention.
But isn't it pretty well settled that we can't grant affirmative relief like reinstating the complaint?
Well, two cases that the Drum defendant cited, Mixon as well as Hecht, both involved not appealing from the appellate division. Here, this was not an automatic leave to appeal. We only had presiding Justice Whalen dissenting, and it was, leave to appeal, but granted by permission. The other two cases, I think, are distinguishable because they do involve appeals at the appellate division where you have an appeal as of right. So I think that I'm requesting that the court look at this a little more carefully than to just simply say that the complaint cannot be reinstated in this case. I think a distinction needs to be made where you have an automatic right to appeal versus where you have to literally seek leave. But in any event, plaintiff certainly, she falls under the second prong of the definition of aggrievement under that this court formulated in Mixon. A person is aggrieved when someone asks for relief against her, which the person opposes, and the relief is granted in whole or in part. And that's certainly true for Drum's appeal of the denial of its summary judgment motion at the Fourth Department. Plaintiff vigorously opposed that. And as I said, then everything else unfolded. As soon as I learned that the court had granted leave to Mr. O'Brien's client, I then contacted the clerk at the court and asked what I could do, and that's how my respondent's brief got filed. One thing that I think is critical is that, unlike the posture in Mixon, the Drum defendants never filed a motion to strike my responding brief in this appeal. So, again, I respectfully request that Your Honors do reinstate the complaint, and really for the following two reasons. Holly Hain's actions of leaving her vehicle and entering the roadway, our contention is, were a normal and foreseeable consequence of Drum's failure to confine and retrieve its cow. At a minimum, there's a question of fact on this point. What is foreseeable and what is normal may be subject to varying inferences, especially in this case where we have a deceased plaintiff. And thus, generally, it should be left for the fact finder to resolve.
So Counsel, excuse me, could I ask you the same question that Judge Fahey asked Mr. O'Brien? How do you distinguish between furnishing the occasion and foreseeability? And I think the hypothetical may have gotten changed a little bit when Mr. O'Brien answered, but this is a farm country problem, but in the city, buses double park, people double park all the time, and if somebody tries to pull out around them, then, we've said that furnishes the occasion. So what is the distinction?
I think the
Isn't it
distinction is
foreseeable
that you have.
someone would come out
I think
behind a bus
I think the
if
distinction
double
is
parked?
that if you do a cost-benefit analysis in this case, the cost of repairing your fence and keeping your animals corralled versus a lady getting killed on a dark country road, I think there's the cost-benefit analysis of that is that the burden on Drum, or the duty of Drum, was very minimal compared to the harm to the plaintiff. But this is a live animal, and I think that Mr. O'Brien did an excellent job of describing that it's moving around, it's dark. She may have not even known what it was. Maybe, I don't know what a calf looks like exactly, but I mean, there are a lot of open questions. I don't think that it was the plaintiff's burden necessarily on a motion that the defendant brought to demonstrate that this calf was in her lane of travel. It was almost like the Fourth Department, the majority said, well, if you can't show that, like, too bad, so sad. But, under Noseworthy, we have a less evidentiary burden at trial. And so why on a motion that the defendant brings for summary judgment is the plaintiff so burdened with an evidentiary standard that really, I think, really is not the law of the state. And those were really my 2 points. Proximate cause is a question here that is subject to inferences, so it should not be decided as a matter of law. And with that, I thank you very much for your time.
Thank you, counsel. Counsel?
May it please the court, my name is Derek Roller. I represent the defendant respondent, Drum Family Farm. And I think the question here today is proximate cause, which exists to place manageable limits on the liability that can flow from negligent acts. And I think to address
Suppose instead of this lady being killed, she got out of her car, did whatever she thought she was going to be doing, and the calf ran away. She continues on, and the calf comes back, and another car confronts the same thing. Is it that the negligence, which was I guess, maintaining the fence, is such that even then the Drum Farm would not be liable?
Well, I think we have to analyze this case in terms of what the negligence caused. And part of doing that in the cases that we cited and what the Fourth Department did in this case was to look at whether the negligence was an active force upon the person.
No, but the argument's being made that, unlike my bale of hay, a cow moves around, calf moves around. And so that made me think that if the scenario I just gave you occurred under the Fourth Department, that calf can wander around for the rest of the night and cause 2 or 3 accidents, and all of them would not be your fault because all you did was create the occasion, and you have no liability whatsoever for having your calf out there.
Well, unlike the Hastings case, for example, that was decided by this court, this does not involve a motor vehicle farm animal accident. There was no injury caused by the calf in this case.
Well, I think there might be some disagreement on that. I mean, there's a lady that's dead.
Well, the allegation in the complaint was that she died solely as a result of being struck by Leah Jamison's vehicle.
Right, but I mean, the competent producing cause of that, besides them, of course, is the calf. That's the whole nub of this, right?
Yes, and I believe that, assuming Drum Farm's alleged negligence caused this calf to escape and wander on or near the roadway, you have to then look at what happened when the plaintiff's decedent, Holly Hain, came upon this calf and the
So you're
unquestioned
saying
facts.
that based on Hastings, the only way that there would be proximate cause here is if the motorist actually hit the calf?
Well, no, the farm animal could cause injury itself if it had escaped property to, say, attacking someone or something of that nature.
What if the decedent and the Jamison vehicle were passing each other and one of them swerved to get around the calf and they had an accident? Would there be proximate cause there?
There certainly could be, but that's also certainly a different case than what happened here.
Well, how is that different?
Well, in this case, Holly Hain encountered the calf either on or near the roadway. We don't know where it was. What we do know and what's agreed upon is she pulled her vehicle over to the southbound side of the road. At that time, she's remaining in her vehicle. She's not in danger, and she's not injured.
So she's supposed to sit there if the calf is wandering back and forth across the road for an hour. She's just supposed to sit there. It's not foreseeable that she would, it's so extraordinary to think that she would actually get out of her car and try to get the calf over so she could go by, and so another vehicle might not hit the calf and have injuries.
I think under the case law that the Fourth Department decided this under, it's almost a different analysis. It's because at this time, when she is stopped on the southbound side of the road and not injured or in danger, the negligence of Drum Family Farm stops being an active force upon her. And the situation that was then created and the risk that was then created of her being struck by a vehicle on the roadway was the one that she created by her own
So
action.
if she had left her car in the street, in the middle of the street, and gotten out, that would not have attenuated the negligence, the cause?
I don't believe that would have changed the Fourth Department's analysis and the analysis under whether it furnishes the occasion or not.
Well, they said importantly, the plaintiff does not contend and did not submit any evidence that would establish that the calf's presence in the road blocked the decedent's ability to travel in the southbound lane or otherwise force the decedent to stop her vehicle. How did they reach that conclusion?
That conclusion is reached because she's pulled over on the southbound side of the road, and plaintiff's counsel admitted at oral argument in the Supreme Court that there was no damage to the vehicle and there's no
No, but to do
there's
that, are they saying that she should not have gotten out of her car? She should not have tried to, let's assume, either assist this calf or do a Samaritan-type act of getting the thing out of the way so the next car doesn't hit it? I just wondered how they reached that conclusion, that she
Well,
should have stayed in her car, should have driven around the calf and left it there.
There were certainly other reasonable options for her to take, but the option that she did take, Drum Family Farms negligence didn't cause her to do that.
Other
Well,
than sitting in
how
the
about-
car,
how-
what's the other reasonable option? On the side that she's on, is there some place that she can go at night by herself?
I don't know that she would have needed to do something like that. I think the only possibly two or three legally significant facts here are that she pulled over on the side of the road, was not injured, and was not injured until she exited her vehicle to go to stand in the northbound lane. And this is exactly analogous to the Eli and Schiff cases that we have cited and the Hurlbut case that the Fourth Department cited. And in
Well,
fact,
do you understand my question from before? I'm having a hard time analytically separating the ideal of substantial factor from furnishing the occasion. I think Judge Abdus Salam referred to something that clearly is furnishing the occasion, the stop buses on the side street. But here, all right, first you got the problem, the calf's in the middle of the road. Now, you'd agree, let's assume negligence on the Drum Family Farm, letting the calf get out. Let's just assume that for our purposes here. You'd agree if she was driving down the road and she ran into the calf, that Drum Family, she just ran into it with their car, and it was either damaged or she was hurt, there'd be no question,
Yes,
right?
that's the Hastings case,
That's an easy one. All right. So here, the only time that I think you could say that the moving of the cow would have to be from the middle of a country road at night, would have to be an act that we would have to consider it unforeseeable and extraordinary to say that this intervening act could break the causal chain. Wouldn't we have to say that? Isn't that what the standard is?
I think that before you get to that point,
Well, I'm just quoting from the case law. That's why I'm asking you if you agree that that's the standard.
I don't necessarily agree that that's the standard. I
Okay.
think
What would
before
you say it is then?
Before you get to that point, you can analyze whether an act that a defendant did was an active force of harm up until the time that the plaintiff was injured, or whether it was not, and other forces acted upon it for which the defendant did not set in motion and were not responsible
Okay.
for.
But I still
Someone's-
want to go back to what do you think the standard is then if it isn't the way I stated it?
I think that the standard is that was applied in Eli and Schiff in the Fourth
Give me
Department.
the
in this
phrase.
case.
What are they saying? I can't bring it off the top of my head. Tell me if you can remember. If you can't, it's not a test. I don't mean to be that way about it. But the way I understand it is that's the test. And if that's the test, that's why I'm having a hard time for it. So really then it comes down to distinguishing the intellectual concept of furnishing the occasion from the substantial factor analysis. And that's where I'm having a difficult time here with this.
I think all I can say is point to the facts in the cases that rely on that furnishing the occasion standard.
Are you familiar with our Gralton case?
Yes.
Okay. And doesn't that suggest that if the instrument of the harm, if you will, is still, ongoing, involved, then it hasn't broken the causation chain?
Yes,
do you agree with
that is part
Okay.
of the analysis.
And here, apparently, the calf was still in the road. So doesn't that mean that the chain was not broken?
Well, the calf's presence in the road didn't cause an injury to her. It
Well,
gave
but
her
that's the
the
question here. Isn't that the question?
No, I
Whether-
don't believe so. I don't believe it's in question whether the calf caused an injury.
Well,
The
if a car, let's say,
Yes,
make it a
right.
tractor, pulled out in front of the car in the road, but the car didn't hit it, but swerved and somebody was hurt, you could safely say the tractor did not cause the injury. That does not mean that there wasn't negligence that caused the injury.
Well, the tractor in that situation was a force that acted upon the person that swerved. The person had to swerve to
Like a
avoid getting
calf.
injured.
Right.
Well, in this case, the person pulled over to the side of the road, and at that time, no one was injured or in danger.
That's your key, right? That there was somehow a break in the time.
Oh, absolutely. She pulled over and was not injured or in danger, and she was not at risk of being struck by a motor vehicle while standing in that northbound lane until she exited her vehicle and went there herself.
So then if the calf had not been in the road, just still on the side, right, on the side of where the farm is on, but not in the road, and she comes up, and as counsel was suggesting, perhaps it's not that obvious that it's a calf, and she's startled, and she hits a tree and gets killed that way. Is there any negligence?
In her vehicle?
Correct.
I would have to say no. You know, calf being on the side of the road,
But if the calf was in the middle of the road,
and she had to swerve to avoid it,
yes.
and in the process of doing that, that caused an act of
She hits
force
a
of
tree and
harm
she gets
upon
killed.
her.
Yes,
That would be a direct cause here.
yes, but being startled by the calf, you say, is not enough. The surprise of seeing something, even though not on the road, but on the side, gets your peripheral vision, you say that's not enough.
No, that wouldn't be enough. I think drivers have a duty to be aware of their surroundings and be prepared for things like that. But if this,
Thank you, Mr. Rolla. Counsel?
I would disagree. It's a continuous force. The negligence here continued right up until the time of the accident. And if it had, somebody was forced off the road, the negligence would continue. When a bus is stopped in its correct location and somebody hits it, the bus is stopped, it's not moving, it may cause the accident, it may occasion the accident, but it didn't cause the
Well,
accident.
you know, the way I understand it, it may be different than yours, but buses stopping is hardly an unforeseen or extraordinary act. That's how I would
That's
characterize
correct.
it.
That's correct, Your Honor. And so is finding someone stopping on a road because they can't get past a moving animal in the road. It's an intervening act, but it's a foreseeable intervening act. It's not a superseding intervening act.
So it comes down, I suppose, is moving the calf out of the road. It's 6 hours old, kind of an extraordinary act that are unforeseeable.
It's not an extraordinary act.
Yeah.
It's not something that would, shock the conscience of a jury.
And there's no signage, like one of those signs that shows animal crossings,
No,
right, farm animal
no, this is
crossings.
dark, rural country road. But talking about the majority, what the majority found, that the majority found that there was no evidence that the cow blocked the roadway or otherwise forced her off. Well, who made that decision? The court made that decision. Isn't that a decision that the jury should be making, the fact finder? That's the one who's been making this. The inference was used against the non-moving party in favor of the moving party, exactly opposite of the way it's supposed to work. All facts and inferences are to be assumed as true on behalf of the non-moving party. The court flipped that below. In Hastings, the court found that there was a danger, and the danger is these cows in the road. The Drum family wants to restrict. They want to restrict that to car and animal only. That's an unnatural restriction. And also, that's against public policy because it disincentivizes cattle owners to keep their fences up and keep their cows in, exactly what Hastings found was a problem.
Thank you, Mr. O'Brien.